Imagine you are a legal officer. We know what a legal officer is. And then your client called you one day and is panicking and just told you that he acquired a land last year. Everything was okay. Documentation, fine. Only for him to realize that the land is under government acquisition. Remember, he got it last year, right? And everything has been done. He has completed his documentation. Only for him to find out that the land is under government acquisition. You now being the legal officer, you ask him, okay, like, can I see your document? He gave you the document, you looked at it, did everything, reviewed it, everything is good on paper. But then he's alleging that the land is under government acquisition. So you now being the legal officer, what would you do in this instance case? Someone said excision. If she is the legal officer, she will apply for excision. Ah, that is good. Like out of 5 marks, I will give her 4.5. That's a pass. In fact, excellent, right? And then surveyor, you said you answered your own. Ignorance of the law is not an excuse. What's that Latin maxim? Ignorantia non something something. There is a Latin maxim for it. If you want to know the Latin maxim, pay me. Okay, well, that's why the way, but I like that ignorance of the law is not an excuse. Now, as a legal officer, the first thing you do, okay, like I already see, the first thing is look at the title, the document. He said, but remember my question is he looked at the document, everything perfect. But then the land is under government acquisition. So the next thing he will do, get the survey of the land, go to Surveyor General's office, and make sure that the land is actually, because you know a land can be under government acquisition and then excision will apply later. Do you understand? Then gazettes. If you don't know all this now, maybe the land was excision was given this year, and then next year you see the under acquisition. You might think it's still not knowing that it's been excision has been given. So you actually go and chart it. You actually have to go and chart it to make sure that it's still under government acquisition. And once it's under government acquisition, you say something about compensation, right? There is no compensation in when a land is under government acquisition. Why? Because it is void ab initio. From the start, there is nothing to transfer. Who will tell me that Latin maxim we talked about last time? There was one Latin maxim I taught us now. If we should, eh? Okay, even if you don't know the word, just the meaning, the English meaning. Yeah, you cannot give what you don't have. Can anybody help with the Latin maxim? You don't have to be a lawyer to know this. Nemo dat quod non habet. Nemo dat quod non habet. That is the bedrock of due diligence. Nemo dat quod non habet. When you are talking to someone, even though you're not a legal officer, and then you're like, Nemo dat quod non habet, as in, what do you think will happen? They will rate you high, right? Your prospect, they'll be like, okay, you know what you're talking about. So we should know this. You don't have to be a lawyer to know some of these things. When someone will say caveat emptor, you know. Someone will say, okay, it's void ab initio. All those little things makes you look, So we should get to know this. So neighbor that quod non habet is the bedrock of every due diligence. My first year of Kotuba, someone approached me and like, barrister, CEO, he gave me like, he paid the landlord. The landlord was like, I've forgotten the facts of the case because it's been years. So, but the thing is, he just accosted me and was like, okay, I have this issue. I think it was tenancy matter. Me itself, that it was, as he was talking to me in my mind, that was my first year. I think I was barely 6 months post-call then. After the question, the man was just looking at me and was like, barrister, what do you advise? I just looked at him and I said, sir, I advise you, let us do 6 to 6, 6 to 12 fasting and prayer for like 3 days. You'll be in court, someone will just come, maybe telling his own side of the story. Their story will be like straightforward, no break, 1, 2, 3, like everything is just in order. The opponent will stand up, tell his own story. Do you understand? No issues. They are looking at, okay, where is the loop? After the whole thing, they're not looking at you. In my mind, I'll be like, your story is straight. Your own, so how do I even come in? Like, and I'll be like, God, these judges, they try you because somebody will just narrate their own story straight. This one will narrate. I don't know where to come in. What will I say? As you're narrating your story, you're tightening your loopholes. The same thing as the other person. So from what he told me, I don't even know what to say. I just told him, okay, let us do 6 to 12, 3 days fasting and prayer. Maybe God will touch his heart. But then let me ask one more question. What due diligence would have prevented that? Can someone give me? I said going to the Surveyor General's office to chart the property would have prevented this whole issue. Remember I said in our last class that before you buy a property, when the surveyor, after the surveyor has done their job, you go to the Surveyor General's office so that they can chart the property to make sure that it's not under government acquisition. Can anyone tell me the two types of government acquisition? General and committed. General is when they don't have immediate use of it, but they know they want to use it in the nearest future. But committed is, okay, we'll be needing this property, and that one, no excision at all, because they already have. So most times when you see property there's excision on a property, just know that it's not under committed. If it's under committed, otilo, nothing. So now, assuming they did their due diligence, they wouldn't have acquired the land. Now that they have acquired and it's under government acquisition, there is no compensation. There is no compensation, right? Because the land is void ab initio. There was nothing to pass to the buyer. The seller had no title to pass. So if the buyer actually wants to take it up with the seller, it should be on a very different note. Do you understand? But as for compensation, no law. You can only get compensated when the land is when overriding public interest. This land is not under government acquisition. It is okay. The land belongs to me. I have a good title. I sold to you. Did everything. You got your own title. Next year, government is coming to say, we have need for this land. Initially, they don't have the need for it. It wasn't under the acquisition. Am I communicating? They're not coming to say this year, I have need for this land. It has to be for public interest. Maybe you want to be the hospital for the community, want to construct road, anything that will benefit the general public should be the bedrock. Okay, we have need for this land. But I understand this land belongs to you. Okay, Mr. Sorry, what's your name? I call you surveyor. So tell me, what's the name? Kingsley, right? Okay, Mr. Kingsley, I understand this land belongs to you. You have a good title to this land. Yes, sir. Okay, since we have need for it, we will compensate you under the Land Use Act. It is provided there. Do you understand? Because you have a good title. So that compensation is like them taking away your title. You have something ab initio. So do you understand? But if it's under government acquisition, nothing. If I come to sell to you, I don't have anything I'm selling. And if you do your due diligence, you would have found out. So if you go ahead and buy a land that is under acquisition, otilo, nothing. You're not getting compensated. All you have to do, take it out with your seller. Sue him to court for misrepresentation. Do you understand? Now that one is a civil matter. For misrepresentation, you just sue him to court, claim whatever he claims. Him will now come with his own defense of buyers beware. I taught us all these things. So you have to be reasoning. You have to do what is called devil's advocate. You put yourself in, just like as we are prospecting, you are talking to your client. You put yourself in the shoes of a client. If I'm my client, will I believe myself? I don't know if you get it. If you actually will not believe yourself, just know you're not doing a good job. So the person you are seeing will also come up with a lot of things. Buyers beware. You did not do your due diligence. The law will fault you. You cannot use the law as an instrument of fraud. I don't know if I'm communicating because am I? 2 days ago, a lawyer called me. He's representing one, he just called me, hello, is this by Star Money? Yes. Okay, I'm representing so person. My client, like, okay, the story, say the client bought one line that on Mommy B Road or so. Say how many years ago it was around 2 million, he bought it. Then now, only for them to find out that the land is under government acquisition. And then the value of that land is about, say, 30 million or so. Do you understand? You made an investment, wasted your time, your efforts, your years waiting for the land to appreciate. Now it has appreciated only for you to find out that you don't even have good title. The land has never been yours. And then I am sure they did not register that land because assuming they went to register, they would have found out early. So that is where the registration also comes in. Remember, right? So all those years, how many years ago, assuming she actually made a step to register, she would have found out because they would not agree. The land is under acquisition. She would have found that early and started tackling it early. Now she has waited almost 10 years only for her to find out. And then you are calling me, will I do magic? She was like, please now, do something. Barrister, are you not barrister of the law? Yes, I must. But the law prevail. What am I supposed to do? Even if I'm a judge, I cannot do anything. I just told her, just take it out with your seller. If you want, we can sue you, but is your seller aware? Are you not supposed to do your due diligence? So the essence of you knowing all these things so that you can actually stop the dispute before they even arise. Do you understand? Make sure that even if it's not outside here, if it's a real estate, your clients wants to buy, tell them, don't be in a rush to close deals. You don't want to close and tomorrow you go choke you for neck and you don't go chop your commission. Do you know? Just tell them, okay, fine, do your, don't always give them that do your due diligence. When you tell a client, don't worry, don't invest first. Do your due diligence. I did it with my client. He transferred the money since to me, pay. I said, oh God, do your due diligence. When I told you how money I trust, yeah, there is trust there. You know, fine. Because we've been dealing, I've been your lawyer over the years. Do you understand? But then do your due diligence. And I also helped him. If you approach the management, I'm like, can I get a survey plan? Can I get this? My client wants to chart the property. They will give you. But most of us don't ask. So if you are talking to your, see now, this is a tip to close deal. If you are telling a client, don't worry, you can go ahead and do your, we will provide you with the details, do your due diligence. They will not look at what is going on in social media, buying receipts. Do you understand? You are giving them, because they go to land Ministry of Land and actually see that the land actually belongs to this company. Do you think they will have doubts? Do you think they will? Okay, let me use this opportunity and ask us this question. So, are you done? Thank you. Okay. Someone went to buy a land. They've actually concluded everything. When he got there, he found that he saw a bacha. You know, we all know bacha, right? And a man has been living there. The man claimed that he's been living there for the past 9 years, uninterrupted. Do you understand? So now this buyer is now like, what do you mean you've been living here? You already paid for the land. He was abroad when the whole thing, based on trust. He said, oh, he went ahead and paid. So when he came back, he now went there only to find a squatter there. And then the person is saying, I've been there for 9 years uninterrupted. What do you mean? Do you understand? Now it became an issue. What do you think is the problem? Actually, what do you think is the answer and the problem? What do you think would have prevented all these things? In law, there's what we call equitable interest. There is what we call equitable interest. The man has been on that land for long. He has an equitable interest in that land. Do you understand? Some of these quarters, you see them encroachers. If you allow them stay for long, the last time I made mention of lashes and acquiescence, when someone has been on your land for a long time, uninterrupted, they have what is called equitable interest. They are not the owners of that land, but you cannot just pursue them anyhow. You have to follow the due process. So assuming that man went for inspection, he would have found out that adverse claim. It's called adverse claim. Sorry, adverse possession, because it's not dragging title. And he would have tackled it when it was still, tender. Now he's coming to contending with this man. I don't know if you get it. So now inspection would have revealed everything. There's nothing like chatting, because here now chatting is actually good. Though. I'm not saying don't do chatting, but here now what would have prevented this whole thing is inspection, so that you would have tackled it. When you inspect, you find. Remember last time I told us, if it's a community land, sometime apart from you going for inspection, go with a village person, somebody in the village. Intentionally, you can just, this is the land, work with the person confidently. What are you trying to do? Resurrecting other adverse claims. Because you know how community, if they see you, I want to say you're working and pointing land. Once you're pointing, tomorrow issues will start coming up. That land though is Mr. KK's own. That land though is Mr. Kafon's own. If you didn't do all those things, so intentionally you do all these things to resurrect adverse claims from people. Because no matter, one senior lawyer told me that you will never know a land that is free until you start something. That's why sometimes you will just go and pay half. Say, please, let me just, even if it's the wall fence, Abi. And all of them we just go out from there where they've been hiding. Now there you go know, and then you've not really committed everything, so that if at the end of the day there's an issue, you're not losing everything. Law helps the vigilant, not the indolent. It's a maxim. Equity helps the indolent, the vigilant. So you have to be very vigilant. Don't sleep on your rights. If you sleep on your right, nobody is coming to rescue you. Are we clear? So now this would have prevented the whole issue. Listen, you are the buyer now. A client brings you a deed of assignment for a property in GRA for you to buy. You look at the deed of assignment, everything is perfect on paper. But then the only thing is that he is in a hurry for you to close the deal. What are the red flags? The question is very simple, right? Like it's not It's not confusing. Do we get the question? I don't know. Am I communicating? Do you get the question? It's in a hurry to close the deal within 48 hours. You've looked at the document and everything is perfect. What are the give me 5 red flags to spot from this? Okay, you made mention of that. Okay, fine. But what we should look out for here is that mortgage. He has given you a document that seems very, very perfect. Remember in my last class, I mentioned it. Someone can have deed over, now, but they have used it to collect loan, and they are coming to sell to you. Do you understand that? So your mind should be very sharp. Like you should, what is this person trying to prevent? There must be something. Yeah, rushing me to close deal. What is it? Do you understand? Because he knows you will likely go for inspection. So if the fault is actually inspection, he will stop you from, but I didn't mention that. Do you understand? So now your mind should be, the question is mortgage. Go and check out for mortgage. Possible liens. Whether it's owing bank, and once it's owing bank has an equitable interest in that land. Do you understand? It's now communicated, it's now dawning on you, Abby? Yes. A widow approached you to buy land from her, emotionally pleading with you that she needs the money to feed her kids, and saying that the husband left that land for her. Do you understand? The husband left that land for her before he died. Now the land belongs, according to she's alleging that the land belongs to her and she wants you to buy. You on your own part, you are desirous of buying the land, but you don't want your money to go to waste. So tell me in this instant, and there are a lot of due diligences. Just give me 2 that you're supposed to do to prevent yourself from entering Otilo. Please. You now see how it works. Okay, thank you. Let me use this opportunity and also throw more light on that. I've done that previously, but why not? Okay, Mr. A and Mr. B. Mr. A dies testate, meaning he left a will. And in leaving your will, you appoint your executors. Executors are the people that will see to the administering of the estate when the person is gone. So we always advise you to choose executors that are younger than you. Initially, you can even choose your father as your executor, choose people based on trust. And most times you find out that even before the person dies, all the executors don't die. Who go come execute? It's just like you just give birth to a baby small now, and you are the father in the Lord and the mother are already old people. Do you understand? By the time the baby even becomes a toddler, they are dead. Don't want them to play the part. You have to choose younger people. That is not actually according to age, right? But then, so you choose your executors, right? And when the person dies, the executors they will be the one to administer the will. When they administer the will, like they will bring out the will, read the will, the lawyer will come out, of whoever will read the will. No, it's not just a lawyer that reads the will. They will read the will, see, okay, what is actually in the will. Okay, Mr. A gave his property to this person, gave this one, gave this one. It is now the executors that will come and prepare the deed of assent. They are preparing it not because they have the title, but they have, it's just like that, them being executors, it's just like them being given power of attorney from the grave to administer that estate. Am I communicating? So they are now, they'll be the one prepare the proof. If you see how probate, if you see how a deed of assent is, it's not saying that the executors are the owners. They are just doing according to the will of the dead. That is it. Now, if Mr. A gave you a property, they will prepare a deed of assent, assigning that property from the grave to you, right? Now, on the part of the person dies in intestate, meaning there is no will, there will be personal representatives that are like, we look at the setting of the family. Yes, meaning the person. I'm intentionally using the word for us so that you get used to it. Yes, this intestate meaning no will. This one, yes will. So when I say someone dies intestate, meaning that. So if you hear it anywhere, I'm intentionally using the word so we get used to it. So whenever you hear it, you don't need to ask question. There are some questions you ask, it will be like you don't even know this, and you say you're a real estate realtor. So now when the person dies intestate, the personal representative, they are always assumed from the setting of the family. Do you understand? People that will administer the will of that person, those people will apply to probate. There's a process for this, but it's not our concern, except it's necessary. It's usually the lawyer that does it. Estate, of course, they know now, they will take their own percentage, do everything. And then the personal representative will now administer the will of the dead person according to the custom and tradition. Now, why will according to custom and tradition? Because the person died leaving, not leaving a will. If you actually left a will, you would specify everything the way you want it to go. But since you did not leave a will, they will administer according to the custom and tradition. If you are, in some custom, even if you are the first son and you are no, like your own no good, no, even if your father disown you, they cannot take out the ogu from you, no matter what. Do you understand? So now the personal representative will administer according to the custom and tradition. And when they administer, what will they do? They will prepare a deed of assent. So now that is where this woman's case is actually leading, a deed of assent. I will